So in September of 2020, Amy Spitalnik talked to the Bard Center of the Study of Hate about what was then the upcoming trial of white supremacists for the role in the violence that happened in August 2017 when they descended on Charlottesville, Virginia, ostensibly to protest against the removal of Confederate monuments. You'll remember tiki torches, Nazi flags, and chants of Jews will not replace us. And there was violence too. Heather Heyer was murdered and scores of people were injured. Amy described then the plans of her group, Integrity First for America, working with a group of lawyers to sue those responsible and what she hoped the case would achieve. After the verdict, I wanted to bring Amy back to discuss what was learned, what surprised her, and of course, what the impact of the case might be. I'm delighted that a key member of the legal team, Jessica Phillips, is here too. As I put in the announcement, there is much material from the case online now. The expert reports, including one by Deborah Lipstadt, who was recently confirmed as the State Department Special Envoy on Anti-Semitism, and also evidence, including trial exhibits, which they'll show you. I don't know if they're going to show you this one, but if you want proof of hate, just click on the exhibits tab. The first one is a picture of the bedroom of James Fields, who killed Heather Heyer with his car, and his bedroom sported a picture of Adolf Hitler and a copy of Mein Kampf. So let's begin. Let me start by introducing our panelists. Amy Spitalnik is the executive director of Integrity First for America, a civil rights organization dedicated to holding those accountable who threaten longstanding principles of our democracy. IFA recently won its groundbreaking lawsuit against the neo-Nazis, white supremacists, and hate groups for the Unite the Right violence, securing multi-million-dollar judgment on behalf of the Charlottesville community members who were injured. Under Amy's leadership, IFA has become a powerful national voice in the fight against hateful, violent extremism, and its Charlottesville case has emerged as a model for accountability. Amy has extensive experience in government politics and advocacy, including as communication director and senior policy advisor to the New York Attorney General and communications advisor and spokesperson for the New York City mayor. She's also worked for a number of federal, state, and local officials, campaigns, and advocacy organizations. She frequently appears in national media and has been awarded a number of fellowships and honors, including being named a Woman in Power Fellow at the 92nd Street Y, a Truman National Security Project Fellow, and the City and State 40 Under 40 Rising Star. Amy graduated from Tufts University. Jessica Phillips is a partner at the litigation department of Paul Weiss, Rifkin, Wharton, Garrison, LLP. She has litigated a variety of complex commercial cases in federal and state and appellate courts across the country. She has experience in a diverse set of practice areas, including employment law, contract law, business torts, securities fraud, constitutional law, defamation, healthcare, and intellectual property. She has taken 5 cases to trial in courts around the country and has experience in California arbitrations too. She partnered with IFA in the successful lawsuit against the neo-Nazis, white supremacists, and hate groups responsible for the Charlottesville violence. Jessica also has extensive experience representing clients in appeals, including before the U.S. Supreme Court. She second chaired Vance v. Ball State University, one of the most closely watched recent employment discrimination cases. She also handled appeals before the New Hampshire State Supreme Court, Delaware Supreme Court, and the 2nd, 4th, 6th, 9th, 11th, and DC Circuit Courts of Appeal. As lead counsel, Jessica argued a pro bono ERISA case before the 2nd Circuit. She's also clerk for the Honorable Joe Flom of the U.S. Court of Appeals for the 7th Circuit and for the Honorable Samuel Alito on the Supreme Court of the United States. So I welcome you both. I appreciate the opportunity for you to discuss with our students and faculty and other friends of the center, this case. And I want to remind our audience that you can populate questions in the Q&A box even while we're going along. After the presentation, I'll moderate those and we'll get your questions answered. So let me start by Amy. Can you start us by giving us a brief refresher of what actually happened in Charlottesville in 2017?
Absolutely, and thanks so much, Ken, and the whole team for having us again. And I'm glad to be here with Jess. I think it's amazing just how much has changed since the last time we were together virtually. both for better in terms of us actually winning this case, and I think for worse in terms of the assaults on our democracy and the broader rise of extremism in this country. So I think there's quite a bit to discuss. And in so many ways, what happened in Charlottesville 4.5 years ago really previewed the extremism that we've seen become increasingly normalized in this country. It's easy to forget that an American city and a college campus came under attack by violent neo-Nazis and white supremacists, but of course, that's precisely what happened. You mentioned the images of Nazis with tiki torches storming the UVA grounds on Friday, August 11th. Those images, I think, are seared in many Americans' minds, chanting, "Jews will not replace us, blood and soil, white lives matter." And they marched through the UVA grounds, terrorizing students who were in their dorms, faculty who were in their dorms on the UVA lawn, and ultimately surrounded a small group of peaceful counter-protesters at the Thomas Jefferson statue, including two of our plaintiffs, Natalie Romero and Devin Willis. And these extremists kicked, punched, beat up, threw fuel and lit torches at these students and community members. Devin said he thought he was going to die that evening. He was a Black undergrad at the time. Nearby, an interfaith gathering had to shelter in place. And I think certainly, as I said, the images of that night, the sounds of those nights, the visceral reaction that many of us have when we see them even to this day is quite something. But the violence, of course, didn't end there. It continued throughout the entire weekend, culminating in the car attack that people know quite well. But it was truly a day of violence that Saturday, August 12th. It was a Shabbat, so the local synagogue was marking Shabbat as it does every week. And these neo-Nazis marched this time on downtown, surrounded the synagogue, which is just a few blocks away from the hub of Charlottesville's downtown. And the only synagogue, I should note, in the town of Charlottesville or in the city of Charlottesville. And surrounded the synagogue, chanting things like Sieg Heil, talking in their online chats about torching those Jewish monsters, carrying semi-automatic weapons. And the detail that always sticks with me, no matter how often I share it at these events or read it in our complaint, is that the synagogue was home to a Torah scroll saved from Nazi Germany decades ago. And in America in 2017, it was once again under Nazi threat. And that just, I think, is a gutting juxtaposition when you think about it. But of course, the violence continued, particularly targeting counter-protesters like one of our plaintiffs, Reverend Seth Wispelway, who was peacefully marching with other clergy members. And ultimately, it culminated in the car attack in which James Fields drove his car into a crowd of peaceful counter-protesters, injuring so many, including a number of our plaintiffs. Natalie Romero, who not only survived the night's attack the day before, but was then hit by the car and had her skull fractured, among many other horrible injuries. Marcus Martin, who's seen in that iconic Pulitzer-winning photo of the car going through the crowd, sprawled across the back, wearing red sneakers and a white shirt. He pushed his then fiancée Marissa out of the way, potentially saving her life. She too suffered injuries. They had been marching with their friend Heather Heyer, who of course was killed in the attack. A number of others, including Thomas Baker and Chelsea Alvarado and April Muniz, who were all injured, of course, physically, grievously in many cases, and never mind, of course, the psychological and emotional injuries that these people still live with today. And what we'll talk about today and what we laid out at trial is that what happened was no accident. It was planned rather meticulously in advance on social media, on text message, in-person conversations, and in a variety of other forums, down to discussions of whether these extremists could hit protesters with cars and then claim self-defense, which is, of course, precisely what happened. And so that's not an accident. That's not a clash between two different sides. That's a violent conspiracy, and we have laws meant to protect against those sorts of attacks. And it's precisely those laws that our plaintiffs used to hold accountable the 24 individuals and groups most responsible. I think you're muted.
Yeah, sorry about that. Like, I've never been on Zoom. Anyway, so Jessica, can you talk to us a little bit about the case at the center of this work, the Signs v. Kessler? What were the plaintiffs actually claiming?
Yep, happy to do so. So our plaintiffs were 9 individuals at the time in 2017, all Virginia residents. who showed up on both the evening of August 11th and the day of August 12th in order to peacefully protest against the hate that was being brought into their community and into their state. Because, of course, the individuals who came bringing their hateful messages and their Nazi ideology came from all across the country. And those individuals were, as Amy just described, grievously injured both physically, emotionally, and psychologically in the violence that took place. What happened shortly after the events of August 11th and 12th is that a journalistic group called Unicorn Riot was able to find and then leak the massive amount of posts and planning communications between the individuals who became the defendants in our lawsuit over something called the Discord. Discord was originally a chat platform established for video game players to communicate. It was very quickly co-opted back in 2017 by white supremacists. And the defendants in the case, as Amy also indicated, meticulously planned the violence and how they would execute on the violence over the course of the summer months before the events actually took place in August. So we brought 6 different counts against the defendants in the case, who were sort of a who's who of white supremacists in 2017. Very high profile individuals, for example, Richard Spencer, who claims to have coined the term alt-right, and then the organizations that many of our defendants had founded and were leaders of, including Identity Europa and Traditionalist Workers' Party, the National Socialist Movement, which is the Nazi party in the United States. And the heart of our case, even though we brought 6 claims, the heart of our case was a conspiracy. And the allegation was that the defendants in the case had conspired to commit racially motivated violence. And that is ultimately what we were able to prove at trial. You're on mute again, Ken.
Oh, God. So thank you. So in November following the trial, you won a $26 million verdict in all the defendants. Can you help us understand the verdict? And can you also describe if there were claims that weren't successful, and what is the impact of all this for the potential outcome?
Yeah, very happy to. So yes, we, of course, rested our case. The defendants put on their case, and then the case went to the jury, which deliberated for, I think, 3 days, after which they found the defendants liable for conspiracy under Virginia law. They found the defendants liable, certain of the defendants, those who participated in the violence and intimidation and harassment against some of our plaintiffs on Friday night, August 11th. They were found liable under Virginia law for those actions. And then James Fields was found liable for different torts related to the car attack itself. And as you mentioned, Ken, and as Amy mentioned previously, we won a $25 million verdict in both compensatory damages and punitive damages on behalf of the plaintiffs. There were 2 federal conspiracy counts that we brought under the KKK Act of 1871 that the jury hung on. And those are claims which we are still in the process of considering whether or not to pursue in a retrial for those claims. But obviously incredibly proud and satisfied by the verdict that we were able to get under Virginia law. We talk about our goals going into this lawsuit, and obviously the goal was to hold each and every one of the defendants that we brought suit against responsible for the conspiracy that they planned, and to get both compensatory and punitive damages on behalf of our plaintiffs, and we did all of that.
Great, thank you. So it was a month-long trial, and there was extensive testimony, and from the defendants, from the plaintiffs. There were expert witnesses, as I mentioned, Deborah Lipstadt, and I know Kathleen Blee, who's a colleague in hate studies, has also worked on your case. But going through that experience of that trial, what struck you the most? What surprised you? What did you learn from it?
Yeah. it was unlike, I'm a trial lawyer. I did 2 other trials last year. So in fact, the Charlottesville case was my 3rd trial last year. It was unlike anything I've ever experienced for a number of reasons. At the most basic level, we were doing an in-person trial in COVID. So we had COVID protocols, and that was obviously somewhat stressful, because if anybody got COVID on the trial team, that puts at risk the rest of the trial team, and possibly at risk are moving forward with the trial, at least in a timely fashion. That's the first thing. The second thing is, we came to sort of feel, because of the subject matter of the lawsuit, we came to feel like we were in this bubble of hate and violence. The defendants were very clear from the outset and executed on a strategy of desensitization. So they spoke at length in their opening statements, in their cross-examinations of our plaintiffs and our experts and other third parties who testified on the plaintiffs' behalf. They did not hold back on their hateful messages. They quoted from Mein Kampf. They encouraged the jury to read Mein Kampf. They spoke at length about their idolization of Adolf Hitler. There were just no apologies for their beliefs and for their violent actions. And so that was extremely difficult. And in some senses, I think, the trial team walked away from trial every day just feeling, a tiny degree of the PTSD that our plaintiffs have all been diagnosed with and have all suffered from, just because when you're faced with that amount of rhetoric and violence and hate on a daily basis, and this was for 4 weeks, that can be quite overwhelming. And then, of course, on the flip side, we had to prepare with our plaintiffs and then put them on the stand. Each and every one of our 9 plaintiffs testified. And I want to just emphasize the bravery of these 9 individuals, because not only were they getting up and telling the jury and the judge about their stories, but they in fact had to face 2 of the defendants themselves, because 2 of our defendants represented themselves pro se, so didn't have attorneys, and were permitted to cross-examine at length each of the plaintiffs. So that also, just a pretty unusual circumstance. But of course, prepping them was emotionally difficult, because this was, the case itself had been pending for 4 years by the time we got to trial. So these plaintiffs had waited patiently for 4 years to tell their stories. And as Amy mentioned earlier, each and every one of them are still suffering from what happened to them back on August 11th and 12th, 2017. So, there was a lot of emotion wrapped up in working with them and getting them ready to tell their stories on the stands. And then a lot of emotion after they were done, just a lot of pride and a lot of, just sort of, we were all in awe of these individuals. And we were very lucky too, because of COVID, the plaintiffs themselves were not actually allowed in the courtroom, with a few exceptions. They were allowed in for opening statements and closing arguments, and then obviously when each of them testified. But otherwise, they were not permitted in the courtroom, because they shut down the entire courthouse for COVID. So we had arranged for them to watch the Zoom that the court made available in our hotel war room, where we did our preparation for trial. And I will tell you, the trial team took an enormous amount of strength from having, their presence. There was, we'd come back after long days at trial, hearing what we heard, and they were always incredibly supportive and grateful, and brought their unique senses of humor. And so that was really a wonderful thing. Obviously at the end of the day, the jury heard all of the evidence, and found in favor of the plaintiffs and against the defendants. So it was a great victory, and we were extremely, extremely proud of the work and proud of our plaintiffs.
Great, thank you. I don't know,
And
Amy.
I was going to say, it might be helpful to just sort of put a fine point on some of what Jess just explained, is to share some of the actual exhibits that our team presented at trial, because they really speak to what Jessica just described, the ways in which the defendants tried to desensitize the jury and the court and the media watching to this vile hate. And I think Jess mentioned, for example, Mein Kampf, but they were making Holocaust jokes on the stand. They used the N-word in their opening statements. It was really as vile as you could imagine. And in fact, one of the defense attorneys said to the media after the verdict that it was a deliberate strategy. And so Joshua Smith, I believe, said that. And so it makes the verdict all of the more powerful in many ways, because after weeks and weeks of being of this defense's attempt to desensitize the jury to this hate, the jury still said that what happened is not okay and that there must be consequences. And I think that that's quite powerful given that strategy. But I can share my screen now and walk through perhaps a few of the most horrific exhibits. And I will warn folks, these are disturbing and explicit in certain ways, as you could imagine. So if folks want to maybe, if that is going to bother you, perhaps step away from your screen for a moment or just listen to the audio. This is sadly a quick taste of what Jess was just describing. And so even going back to the planning chats, this is from May of 2017, you see this post by Jason Kessler, who is one of the defendants and the lead organizer of Unite the Right, talking about how he wanted this to be a, quote, battle of Berkeley situation. And they ultimately called this a battle of Charlottesville in their internal communications. Publicly, this was Unite the Right. But internally, it was always described in these violent terms as a battle. And you can see that in this post from Jason Kessler from months before it actually happened. And similarly, this June text message from Jason Kessler to Richard Spencer, as they were discussing Spencer's role as a leader in the alt-right and coming to participate and help lead this effort. Kessler said to Spencer, "We're raising an army, my liege, for free speech, but the cracking of skulls if it comes to it." And as has been mentioned a few times in the Discord chats, there was extensive discussion of whether these extremists could hit protesters or counter protesters with cars and then claim self-defense. So here's one post you can see in the bottom. Well, of course, it's an image of a bus going through a crowd. But it says on the bottom, "I know North Carolina law is on the books that driving over protesters blocking roadways isn't an offense." And of course, it was followed by a meme about John Deere's new multi-lane protester digester, indicating exactly what they intended to happen. Tyrone, who posted this, is a man named Michael Chesney, who was a third-party witness in the case. And of course, it didn't stop there. There was other extensive violent conversation among the defendants and others, including, there's always the delightful username that comes up of Crystal Knight, a play on the word crystal knot. And you can see here, Chesney posting about the perfect size flagpole to use to bludgeon someone with. These were in chats in July of 2017, a few weeks before Unite the Right. And here we have texts from Richard Spencer on August 7th, just a few days before Unite the Right, talking about how he's willing to risk a lot for the cause, including violence and incarceration. "I want to coordinate and make sure it's worth it to our cause." And then this is, I think, certainly one of the most heinous memes that were posted in the planning chats. This is from Asmodor Ray, another defendant, and a prominent writer for the Daily Stormer, who posted what you can all see here as the N-word tote, a device to carry around your slave, which is truly as horrific as you can imagine. And of course, it was also replete with Holocaust imagery. This post of a bunch of original Nazis, including Hitler, where Asmodor says, "Get in, loser, we're invading Charlottesville." There's a few other quick exhibits that I'll walk through while I'm sharing my screen, and I suspect that they will be relevant to this conversation. Of course, as the violence in Charlottesville was unfolding, these extremists were also promoting that, including a post on Facebook by the Traditionalist Worker Party, one of the defendants, led by another defendant, Matthew Heimbach. And in this post, where they celebrate the successful torch march and say, "We will not be replaced," Facebook actually, through its algorithm, encourages the defendants to boost this post and ensure it reaches more people. So I'm sharing this now because I suspect it will be relevant later in the discussion as we talk about what other tools we need to be using to address extremism. And finally, we want to share a couple posts from August 12th and the days following the violence in which the defendants and others celebrated what happened. So here is Dylan Hopper, another prominent white supremacist leader, who says, after Heather Heyer's death, commies died, that's good enough for me. Here's defendant Chris Cantwell saying, if you think the alt-right is insignificant, you might want to ask the bleeding commie filth we sent to the morgue and hospitals how insignificant we are. And then here is a letter from defendant Matthew Heimbach to defendant James Fields, who is by now in prison, in which Heimbach sort of lauds Fields, calls him a good man, and talks about how he obviously went to Charlottesville for a future for himself and our people. Of course, includes tons of racist and anti-Semitic language as well. But the point being, in the days and weeks following Unite the Right, there was no remorse for the death and the extensive injury that these extremists brought to Charlottesville, but rather they extensively celebrated what happened very explicitly, very horrifically on social media and in other channels. And as was mentioned by Ken at the beginning, all of the exhibits that were published at trial to the jury are available in a searchable database on IFA's website, i4a.us/exhibits, or you can just go to integrityfirstforamerica.org and search the exhibits yourself, particularly for students, researchers, academics, journalists who wanted to make sure that these were available for people to really see and understand. Because I think they put quite a fine point on what Jessica and I have been discussing here in terms of the efforts, of course, the racism, the anti-Semitism, the violence that was that really fueled the planning for Unite the Right, and of course the defendants themselves tried to make so commonplace during trial itself, to the point of trying to desensitize the jury, and thankfully did not succeed.
Thank you for that. So it was a masterful job walking through a month-long complicated trial and the highlights in a very compelling.
There's so much more that I skipped over. Those are some good examples of sort of what we're talking about here. And everyone can read the full horror on our website if you so choose.
No, I appreciate that. So before we talk a little bit about the legacy and the implication, I have a couple of other questions about just sort of procedurally. So is there an appeal that are the defendants appealing?
Sure. So let me handle that. So obviously the trial is done, the verdict is in, and there are always post-trial motions that both sides get to bring. And we filed a motion, for example, for our attorney's fees related to the 4-year effort to bring this case to trial. The defendants have filed their motions, a few motions for new trials, sufficiency of the evidence challenges, that kind of thing. And obviously we'll be responding to those. And once the court has settled those, after those are decided, then there will be an opportunity for appeals, and that is obviously yet to be seen. I think we anticipate that at least some of the defendants will be appealing the decision to the Fourth Circuit, the federal court that oversees the Western District of Virginia court where we had our trial. So we'll see how that plays out. But yes, I think we're anticipating an appeal from at least some of the defendants.
So your work isn't over. That's important for people to know.
That's right.
So another quick question before we talk about the implications and the legacy of it. So I was sort of intrigued by you both highlighting, and again, even more so, the sort of what seemed like the defense strategy of trying to throw out as much vitriol and hatred as possible to desensitize the jury. So I have two questions about that. One is, did you have an opportunity to talk to the jurors later to get a sense of how that impacted them? And secondly, Jessica, I mean, years and years and years ago, I used to be a trial lawyer, and one of the things I used to do was to, think through if I were on the other side. So I wonder if you thought about, would there have been another strategy that they could have used? I mean, you guys had all the evidence of these horrible things these guys said. They weren't going to be able to hide it. So, was there another approach that might have made more sense for them that you think of?
Do you want to handle the first question first? We can take them in
Okay.
turn.
Me, do you want me to?
Oh, I thought it was directed to you.
Oh,
Sorry.
sure.
No, either of you, but that's fine.
Well, I will say also in the second question, they really tried so many different approaches over the 4 years of this litigation that I'm sure Jessica, as someone who's had to respond to them, could probably remember some of them even better. But on the desensitization, I think, I'm not sure what more to add other than it. I mean, I don't think anyone on our team has spoken with a member of the jury, as far as I'm aware. I don't know if, I'm assuming you concur with that.
Yeah, no, that's right. We did not have an opportunity.
Yeah.
That's unusual. There's a local rule in the Western
Okay.
District of Virginia that requires good cause to be shown to speak with the jurors. So
But I
the
think
preference in that court is to leave the jurors alone after they've done their job.
Okay.
But I think the fact that they landed on the verdict that they did meant, thankfully, that those strategies did not work. And there's at a moment when it feels like there's not a lot of justice and accountability, particularly in this space, that at least for me was a reason for hope. The fact that there was such a resounding verdict in terms of, as Jessica described earlier, both the compensatory and the punitive damages that they awarded. And so I think that at the end of the day, despite that being a deliberate tactic, it did not work. But it is indicative of the broader moment we're in, when we're seeing extremism become increasingly normalized, with replacement theory and other forms of extremism seeping into the mainstream through media, through elected officials, through political candidates. And so it also, in many ways, much like Unite the Right previewed the cycle of extremism that's followed, so too did this strategy really shine a spotlight on the broader extremist strategy of the moment to try to normalize and desensitize as it relates to these issues. And that's an important context to see this in, I believe.
Thank you. Jessica, you have anything to add? Or
I was just gonna answer the second part of your question
Sure.
as well, and talk a little bit about the defense strategy. And Amy's right. We saw putting aside trial, over the course of the entire case, we saw a number of different kinds of strategies, ranging from some of our defendants filed in bankruptcy court, trying to see if they could avoid a judgment in the civil litigation that we brought. Some of our defendants were initially engaged in the litigation, and then after some initial wins in discovery that we had on motions to compel and getting access to the materials that all civil litigants are entitled to get access to, we saw them change strategy, and some of them just dropped out of the litigation altogether, refused to show up to conference calls with the judge, refused to participate in litigation. We had to fight to find those folks and get them on the record. We filed over a dozen different motions to compel and motions for sanctions. We had four different basically mini hearings on civil contempt for two of our defendants, one of whom was actually put in jail after being held in contempt after 3 different hearings, and an arrest warrant was issued after the 4th for a second defendant. And then, in terms of trial itself, when you're faced with the overwhelming amount of evidence that we had in this case, in part because, of course, we fought tooth and nail over the course of 3.5 years in discovery to get access to what we knew we were entitled to. They had very little choice but to sort of just own who they are, what they believe, and what they did. I mean, a lot of what we saw was, yes, we said those things, but we saw this was we're just joking. These are all just jokes. It's not tasteful, and you may not like it, but it's all jokes. And so along those same lines, this is protected free speech. And of course, the judge held in motions to dismiss and resolving the motions to dismiss against the defendants that violence has nothing to do with free speech. Of course, you can't conspire to commit racially motivated violence and claim free speech. We also saw we saw a lot of ownership of their beliefs, not just the desensitization, but it can take the winds out of a cross-examination if you just admit to a lot of things. And we saw that happen on a number of occasions. We also had the opposite. Some folks really wanted to fight and take issue with the evidence. That didn't go well for them because, of course, as I said, the evidence was really overwhelming. So we saw a bunch of different kind of strategies, tried out, and as we know, because of the verdict, ultimately failed.
I just want to one thing that Jessica raised, I was just joking strategy, which was quite common. And in fact, Pete Simi, who worked with Kathy Blee on that report you mentioned, spoke and testified specifically to that. The report is on our website, as is the testimony transcript. And I would encourage folks to take a look at it, because Pete in his testimony and Pete and Kathy in the report really tear apart that whole argument, this idea of plausible deniability that so many extremists and white supremacists in particular use as a deliberate tactic to try to avoid accountability. And I thought it was brilliant by our team to have Pete testify to that, because it really took the wind out of the sails on that argument. And I think laid out, for probably, at least as far as I know, for the first time in an open court like that, and certainly for the first time for many of the reporters and average people listening in a way that helped them understand these tools and tactics that extremists use, pulling back the curtain on the movement in a way.
Yeah, and that, to me, I mean, two of the legacies of this case, or one is the amount of hard work you guys did to make sure you won the case. So that is kudos. And then again, what Amy was just talking about, the type of information that you made available to look more deeply into not only these groups but the implications of it. So let me ask you one more question, then I'll ask. I see there are some questions in the Q&A, and I encourage people to put in more. So there are some people on the call I know who are old enough, like I am, to remember, cases like the one the Southern Poverty Law Center brought years and years ago to close down a Klan group and pay money to its victims, and the case against a white supremacist group in Portland for killing an Ethiopian immigrant, and its work shutting down in 2001 the Aryan Nations compound. So all for crimes that took place. So how does this case fit into that legacy and the broader fight against hate? And how do you see this case now as part of that legacy, if it is, providing a model for future litigation?
Do you want me to start, Jess, and then you can jump in? Sure. Well, I think this is absolutely part of that legacy. I think there's a strong history of civil litigation in this country that has been very effective at taking on the finances and the operations of extremists and holding them accountable for their violence. And you mentioned a number of those key cases. I think in recent history, sort of the last 10 to 15, even 20 years, there haven't been many cases, partially because extremists until the last few years were in the shadows in many ways. But certainly given the rise of white supremacist violence in this country, it was clear to our team, to IFA, to many, that there needed to be some semblance of accountability and justice at a time when there was so little of it. And so this really was, I think, the first case like this in the modern era. And what's been heartening is to see how it's now really emerged as a model. There have been a number of cases brought related to January 6th. I know Paul Weiss is involved with some of them, including the case brought by the DC Attorney General, which the AG has said is modeled on ours, and that the momentum created by our case has been very powerful in illustrating the importance of civil litigation. Certainly there are criminal prosecutions happening. We're seeing them unfold right now related to January 6th. But I think civil litigation is a uniquely important tool because of the financial and operational impacts, because of the discovery, as you just mentioned, the ways in which it can really illustrate the tools and the tactics and the strategy at play for these movements. And so seeing this case become a model, seeing government officials like an attorney general bring a case modeled on ours is incredibly heartening. It's not the only tool we need to use, though. You can't sue your way out of this problem. You can't prosecute your way out of this problem. And that's why, of course, the work that you all are doing at BARD and so many others in the anti-extremism space are doing is so important and complementary to cases like this. Certainly civil litigation, certainly criminal prosecutions, but we also need to be thinking about, for example, the role of social media, as that post I shared earlier illustrated, how the algorithm not only encourages, but enables violence and extremism in many ways, and what we as consumers and as advocates can do. We need to be thinking of a broader whole of society resiliency approach to how we prevent people from going down the rabbit hole of extremism in the first place. And this ties directly to the broader fight for our democratic institutions and norms, the fight for voting rights, the fight for so much more. And of course, there's work in the de-radicalization space and so many others. And so it doesn't stop and start with civil litigation, but I think it has historically been a crucial tool. And as this case illustrated, and now the subsequent January 6 cases illustrate, it's a really important tool at a moment when we need such accountability and justice.
Thank you. So let me take a couple of questions. One is just sort of a technical one. How long did the jury deliberate for?
For 3 days.
3 very long days.
It seems
Yes.
long at the time, but that's
Yes.
but they got the right result. So let me see. Some people have asked about sharing the material for the website and stuff. Everybody will get an email tomorrow, and I'll put links to all this material, so you don't have to worry about doing it now. Everybody who's registered will get that. So one said, as important as the trial victory was, there will be many more. I believe the dangers facing us as a country can't be solved in the courtroom. What can be done to lower the anger and reduce the hate in the proverbial court of public opinion? I fear that most Americans just aren't paying attention.
Do you want me to start or to?
Sure.
Well, I think as part of this is I suspect that question was sent just before we addressed part of it in the last.
Yeah.
I wholeheartedly agree with the premise. And I think in particular, there's a lot of folks in the space like Cynthia Miller, Idris, and others who have been talking about this question, the sort of whole of society resiliency that we need to be building so that we're not simply responding to extremism, which is what we've been doing. And I think the ways in which we're responding have been sorely lacking, particularly when this case was brought. There was a DOJ led by then AG Jeff Sessions that was pretty clearly not going to take action. And so it fell to private plaintiffs like ours. And even now we're certainly seeing action by the federal government and by other levels of government in a way we haven't seen, but you can't, as I said, you can't sue your way out of this problem. You can't prosecute your way out of this problem. We need to be on the offense in many ways, which means thinking about how we're preventing it in the first. I don't know if that's defense or offense. My sports metaphors got a little muddy there. But we need to be thinking about how we prevent radicalization in the first place, particularly again at a time when we're seeing extremism become increasingly normalized. Even just thinking about the Supreme Court confirmation process, how it was used by some elected officials to normalize QAnon conspiracy theories about pedophilia. And white supremacist conspiracies directed at our now confirmed new Supreme Court justice. And so we need to have I think we need to have very clear eyes about that even as we are having victories like the one we had in court in November, we're seeing this broader normalization of extremism, replacement theory being, promoted on Tucker Carlson every night. And by elected officials who just sort of espouse it on the campaign trail and in their day-to-day lives without much consequence. Just yesterday, it was announced that Paul Gosar, a sitting congressman from Arizona, is attending and headlining a white supremacist conference on Hitler's birthday. Something like that would have been front page news maybe 5 or 10 years ago, but we sort of brush it off these days because it's become increasingly commonplace and normal. And so we need to be not just attuned to that, but really pushing our officials and our democratic institutions to respond to that by making clear it can't become normal. It can't become mainstreamed in the way that it is.
Yeah, and one of the challenges is that historically, appeals to hatred in politics works. Otherwise, politicians wouldn't use it.
Exactly.
And that's a big challenge. So another legal question, let me ask this. What, if any, advantage from both civil litigation perspective and from the broader anti-hate and extremism perspective would a verdict under the federal KKK Act over the Virginia statute verdict?
Oh, it's a good question. In my view, none. Obviously we would have been thrilled to have won the 2 federal counts that we brought as well. But as I said, our goals coming into this litigation were to make sure that each and every one of the defendant, we didn't want, obviously we alleged a very big, very broad conspiracy. There were over 20 defendants, both individuals and organizations. And our goal was to make sure that each and every one of those were tied to the conspiracy. And we did that. And that we got punitive, compensatory and punitive damages on behalf of our plaintiffs. And as I said, we did that as well. And then, so from a legal perspective, none in my view. And then in terms of the broader impact, I don't think any. I think the fact that these additional, the KKK Act is 42 USC 1985. We sued under sub 3, and the January 6th lawsuits, I believe, are being brought for the most part under sub 1, but they are following in our footsteps, regardless of the jury being unable to reach a verdict on those 2 counts. So my view is that the impact has been had just by virtue of our having brought the lawsuit and sort of paving the way.
Right. So let me ask you, because you sat through this for a month and went through all the discovery, can you explain the correlation, or in the defendants' minds, as you understand it, between the role of anti-Semitism and the role of racism? How do those things correlate as you saw them, their evidence and the trial unfold?
Do you want me to start, or was that for Jess or me?
For either one of you.
Go ahead.
Yeah, I mean, this has really been sort of what we've lived and breathed at IFA for the last 3.5 years. And I think as Deborah Lipstadt testified at trial, and frankly, as the evidence in this case laid out, you see how anti-Semitism is used as a tool to further white supremacy, how it animates white supremacy, racism, xenophobia, and other forms of hate. And so when you hear something like Jews will not replace us, it speaks very specifically to just that, to how these tools intersect as wielded by these extremists, that in every good conspiracy theory, there has to be someone ultimately pulling the strings, the puppet master, and it's very often the Jews in many conspiracy theories, and it certainly is here. So any success that the Black, Brown, immigrant, refugee community has, whether it be, immigrants coming up into the United States searching for a better life, whether it's the success of the Black Lives Matter protests and putting attention or a spotlight on racial injustice, whether it's our first Black president. I'm sure certainly our first Black Supreme Court justice is going to be tied into this, I'm confident. There has to be someone pulling the strings, because those communities on their own couldn't possibly be capable of that success per the white supremacists. And so that is really at the core of what this replacement theory is, and what so much of these ideologies intersect. Certainly it manifests in obvious ways when it's neo-Nazis with torches chanting Jews will not replace us while attacking Black and Brown students and supposedly protesting the removal of a white supremacist monument. It's a lot harder to identify, but I think even more dangerous in certain ways when it's this more insidious, subtle form. Calling out George Soros for funding a caravan coming up from Central America, or his support for the Black Lives Matter protests, or the ways in which a lot of elected officials talk about a globalist plot to replace the Republican electorate with immigrants and refugees. And that is at the core of this very same replacement theory. It just manifests in more subtle ways that again speak to the mainstreaming of extremism. But at the end of the day, what this tells us is that no community is safe if one community is unsafe. That, as I'm a Jewish American, and my fate, my security is inextricably linked with that of Black and Brown and other communities, because I know how anti-Semitism is wielded to further hate against those communities and vice versa. And so we need to understand that. I think our case really put a spotlight on that in a way that perhaps in the court system hasn't happened. Having Deborah Lipstadt testify to that, having Pete Simi, having just the evidence in this case, which illustrates it in really alarming detail, was remarkable in many ways, because you don't really see that form of extremism get the coverage or the attention that I think it warrants at this moment, in terms of calling it out for what it is, which is violent extremism.
Yeah, Amy, if I could sort of follow up on that, because there's a question that sort of goes to what you're talking about, sort of the mainstreaming of the ideas of hatred in society. You know, to me, I've always looked at the question of hate about whether, you know, it's on the margin where it's always going to be, or is it driving politics? Is it, you know, seen in the mainstream? And I think your comments reflected that too. So the question is, some state legislatures have been active to restrict what books can be read in the classroom and held by school libraries, and what reproductive options are available to women. Won't legislative efforts like this serve to fuel the anger? I would phrase it a little differently. Wouldn't it actually make those folks that are vilifying others in our community, whether by race or gender, whatever, won't they feel empowered that you have these legislatures doing that? I mean, just like Trump was talking about the very fine people at Charlottesville.
Yeah, I wholeheartedly agree with your assessment that I think at the end of the day, this broader assault on our democracy that we're witnessing directly connects to and is inextricably linked with the white supremacy that we saw in Charlottesville and the broader extremism that we're witnessing. And so I think, you know, we were talking about voting rights, certainly related to white supremacy, talking about, and that connects to both the assaults on our elections, the supposed claims of election integrity, and using that to disenfranchised Black voters for the most part. Of course, reproductive health. We think about who's disproportionately impacted by restrictive reproductive health laws. It's Black and brown communities. And of course, there's a whole other rabbit hole you could go down to in terms of abortion rights and the white supremacist movement, and how the white supremacist movement has historically sought to restrict abortion rights because of population-related questions. And Elise Hogue, the former president of NARAL, wrote extensively about this. You could talk about the attacks on education and book bans and the red herring of critical race theory. All of it is about fundamentally attacking what we all know to be true. And we saw that in this case as well. I think, frankly, one of the reasons this trial was so important is because it put on the record for the first time the full truth of what happened in Charlottesville, both through the complaint that our team brilliantly wrote and through the trial itself, which there's now a public record of. And having the facts out there at a time when extremists are trying to ban books, ban history, and say that, you know, don't believe your lying eyes, it's so important to have history and truth be out there on the record. And this case did that. But I think you're absolutely right that you have to see the sort of horrific acts of extremism like Charlottesville in the context of the broader assault on our democracy and how they're interconnected. And when you think about what fuels these state laws and other developments we've seen in recent years, at the core, they're symptoms of a white supremacist system.
I get a question that's looking at this from, I guess, the other way. Are there some change, I guess it's for Jessica, are there some changes to federal or state law, either civil or criminal, that are needed to more effectively combat extremist hate?
Yeah, it's a great question. I mean, obviously, we were able to find private rights of action under both federal and state law in order to bring this lawsuit. So, you know, what we have is obviously sufficient. Is it enough? You know, probably not. I do think, you know, there's been a recent announcement of a new unit within the Department of Justice, which is the Domestic Terrorism Unit, which is new. And I think those of us who operate in this space in the legal world are going to be following what comes out of them and their efforts pretty closely to see what kind of impact they have there.
Thank you. Well, we have about 5 minutes left, so I want to save a couple of minutes for you guys to say whatever else you want to say. But I have one final question, I guess, for Amy. Now that this, you know, the case is over, other than the fact that you're dealing with the post-trial motions and the appeal and so forth, what's the agenda for IFA? What do you see yourself doing in the next few years?
It's a good question because I think there is so much need at this moment. As we're talking about, winning this case was remarkably important for a number of reasons. And, of course, we're focused right now on making sure the team has what they need to finalize these post-trial motions and reach resolution there. And then, of course, ultimately there'll be judgment collection and making sure that systems are in place so that our plaintiffs can collect on the final judgments, the final damages. And even just a couple of days ago, our team won, I think, over $18,000 in additional fees and fines against Asimidor Ray, another defendant. So well beyond what was won by the from the jury in November, there's also these other fees and fines, as Jess mentioned, a motion for attorney's fees that our team put in last month. And so once that's all resolved, we're going to want to make sure that there are systems in place to collect on the judgments. But more broadly, I think a few things. First, making sure that this case can really remain a model and a resource for others in the space. We're seeing that with these January 6 cases, and it's been very heartening. I used to work in the New York AG's office, so seeing an AG bring a case in partnership with a number of nonprofits and Paul Weiss has been just wonderful, and a silver lining of, not a silver lining because the victory itself in court was very nice too, but I think has been a very positive outcome in addition to the other January 6 cases, and continuing to make these resources available to the extent we can, as we did with the database on our website, which is at integrityfirstforamerica.org. I know some folks were eager to see that, and I know Ken will send it out after the fact. And then, of course, thinking about where we can take the energy and the enthusiasm for the work we've been doing over the last few years and continue to fight for our democracy, because I think that's what this is all about. At the end of the day, when you think about extremism, when you think about white supremacy, it all ties into this broader assault on our democracy, whether it be taking on violent acts of extremism like we saw in Charlottesville, or the assault on voting rights, or so many other bills and efforts to undercut our democracy in every form. And so we're thinking about what that looks like. We're taking suggestions from and talking to smart people, because what's been heartening, as I said, is seeing the strategy of this case really become a far more prevalent strategy in the space over the last few years, which this case really helped pioneer. And that's wonderful. And where we go from here means both supporting that and making sure the broader fight has the resources it needs.
Thank you. And Jessica, we have a couple of minutes left. So there's one short question which you could answer probably very quickly, and then anything else you want to say. The short question is, do defendants have the resources to pay the amounts awarded?
Yeah, it's a good question. So certainly we think some do. And as Amy said, next steps after we get through post-trial briefing and then any potential appeal is to make sure that there are systems in place to chase down the defendants and do what we need to do to make sure that the plaintiffs see the damages that were awarded in this case. We'll certainly be doing that. And then we have asked for, we'll see what the judge ultimately says, but there's a question of joint and several liability. So we'll definitely be chasing the defendants, I think, for quite some time. But we do anticipate to be able to hold them accountable.
Great, thank you. And let me just say one thing to Amy's point about where you're going to be and what you're going to do. As I emailed you like a couple of months ago, I was so delighted that you were putting this stuff up on a website. I was involved in the Deborah Lipstadt, David Irving case, and one of the things that we were thinking about from the beginning is how to not just use this in the courtroom, but use it in a way publicly. And that site is still there. If anybody wants to go see it, it's hdot.org. It has all the stuff from the Deborah Lipstadt case. But I can tell you, I'm teaching a class for the Open Society University Network, virtual one, next fall that may have students from Bard and places in Central Europe, where Orban kicked out of the school from Budapest, to Vienna, and Bard affiliated schools in Britain and Central Asia, and there's even a Bard affiliated program for refugee students, where students are taking classes in refugee camps. in Jordan and Bangladesh. And the class is going to be on anti-Semitism in the law, which I think gets way too little attention, both how law has been used historically to promote anti-Semitism and the cases that have actually shown some capacity to help us understand it and combat it. And one of the things I'm going to be having the students do is look at some of the material from your case. And I'm really thankful for that opportunity. And I hope you find, other opportunities to use it in educational institutions. And I'm happy to help you figure that out if that's what you want to do.
Yeah, we would love that, I'm sure. And it just brings me such joy to know that it will live on in that way and be useful, because as I think all of us wanted to make sure that the legacy of this case lived on well beyond the verdict and well beyond court. And certainly that's the goal of making as much accessible as possible. And so if anyone wants to work with us on that, if there are professors or others on this, just reach out to us via our website or contact at integrityfirstforamerica.org, or Ken can put you in touch, I'm sure. And we would love to make sure you have what you need to do the same, because it's so important to us.
Great. Well, it's the top of the hour, so I don't want to keep you or the audience anymore, but I want to thank you for sharing all this great knowledge with us, and even more so for all the work you've done for the last few years. I know it was intense, but it was very worthwhile, and it's deeply appreciated by all of us who care about fighting hatred and doing it effectively. And I will send out to everybody tomorrow not only the connections to your website and so forth, but a link to a copy of this. I know one person couldn't see the screen on his mobile phone, but so everybody will be able to see all the exhibits that Amy put out tomorrow. And again, thank you all very much, and have a good rest of your day.
Thank
Take
you.
care. Yeah. Okay, bye-bye.